time, I've become such a big believer in front loading the process. The more we can front load in general and have people walking into the room with similar understandings about things and everything from what we're there for to how we're going to accomplish it and who needs to be a part of it and what they submit to us in advance, that all of that, the more we front load, the more we avoid the kinds of what other people call impasses.
The only good idea is to let me and John do our job and mediate this thing right here.
You want to hear the crazy thing? I know it doesn't feel like it, but we're making progress.
Settle! Settle, 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 settle!
I don't want to settle.
All we're trying to say is, put your swords away for a second. Let's finish this and let's move on.
Welcome to Mediator in the Middle. This is your place to peek behind the curtain of what a mediator is really thinking. I'm your host, Abe Melamed, a litigator turned mediator. In this series, I, along with world-renowned mediators, will offer you, the clients, the lawyers, the parties to mediations, tips and tricks on how to be more effective in mediation and ultimately get yourself the best result possible. Thank you for listening. Please enjoy. I'm your host, Abe Melamed. I'm a mediator specializing in helping parties resolve employment, business, and tort disputes in California, New York, and Arizona. We're really honored to have a special guest today, Lee Jay Berman, who is probably one of the foremost thought leaders in the space of mediation, alternative dispute resolution, and who I can say is a phenomenal trainer because I did some of my mediation training with him and with some of his courses. But if you don't know who he is, you should check out his bio on his website, and you can really see the full length of it. He recently was actually named as one of the top 10 global thought leaders in mediation in North America by Who's Who Legal. He's been mediating for 28 years, I think, at this point. Is that right, Lee Jay? Yeah, wow, time flies when you're having fun. 20, 25, 2,600 matters that you've done at this point in employment, entertainment, tort, personal injury, business, many high-profile cases. I won't get into too much of the detail. People can look at it, but, master mediator for employment matters with the AAA and panelist with commercial, distinguished fellow with the International Academy of Mediators, really just a distinguished neutral of the year at some points, named that by different magazines. I think everyone knows, I would say you're one of the founders of many of the thought into the mediation process. You've been doing it for a very long time. And so I'm very honored that you take the time and join us, and we'll get into kind of the topic in a moment. But anything I missed there in terms of the introduction, anything you want the listeners to know?
No, Abe, it's just my pleasure. People like you and me, we're just out there doing what we do every day and trying to help people get along better. So the credentials just come with time and age.
I guess that's fair. And I think that's a great way to distill what it is that mediation is. It's just helping people get along with each other. And so I think today the topic is maybe a little more nuanced, and the real purpose of this podcast is something that maybe doesn't exist as much out there, is helping the lawyers prep for the mediation, helping them help us help them, if that makes sense. And I think the topic is something that I know you're passionate about and I'm passionate about, and that is give us as much information as you can before we start. And that's kind of the broad title, is an information exchange before the mediation. It's the mediation briefs, it's the exhibits, it's pre-mediation phone calls. And we'll get a little bit into that, but anything you want to just say off the bat about that process?
Just generally that over time, I've become such a big believer in front loading the process. And I think there are a lot of mediators who are very confident, and I used to be one of them, who would walk into the room and say, give me what you got, and just sort of wing it and settle cases right and left from that place. But what I've learned is the more we can front load in general and have people walking into the room with similar understandings about things and everything from what we're there for to how we're going to accomplish it and who needs to be a part of it and what they submit to us in advance, that all of that, the more we front load, the more we avoid the kinds of what other people call impasses that show up at 4, 5, 6 in the afternoon. I think we have the duty, if not just the ability, to manage that up front, and better mediators, I think, do that.
Yeah, I agree. And I think that's a great way of phrasing it, is that it's really a duty and obligation, maybe one that lawyers can be better about, because I find often, and I litigated for many years before I shifted, I know you have a different background to some degree, but at the end of the day, if you're not giving that information to the mediator, you're not helping your client. That's probably an obligation you should be more focused on, and sharing that information. I don't know how often it is, but frequently enough that it leaves an impression in my mind. I'm helping the lawyer develop their case the day of the mediation, and sometimes it's bad because they say, wow, this is actually a more valuable case than I realized. I don't know if we can get this settled, but I think that having that information exchange is important. And so the first piece to this that I'd love to get your thoughts on is the confidentiality of the process, and we'll get later on into the kind of pitfalls that come with that. But the way I view it is that there are two different pieces to the confidentiality process, and maybe this is just me parroting you from the training that I did, but there's the confidentiality of this doesn't leave the building today. And you can't share it with other people. You can't use it in the litigation. Of course, you can't shield yourself from turning over things that you otherwise would be obligated to just because you've traded it. But it doesn't leave today. And then the second is just sharing it with me as the mediator, and you as the mediator to evaluate, even if I'm not going to share it with the other side, because the good, the bad, and the ugly, we should have it all to help you be able to evaluate that. A lot of what we're doing is facilitating, but a lot of it is evaluating. So what are your, how do you approach that going into the mediation and make sure the parties feel comfortable doing that exchange?
So fantastic question, and multi-pronged. Let's take a half a step back.
Sure.
There are two things about what we just talked about front loading and showing all of our cards. Attorneys first have to make up their minds that this is going to be a different process than the litigation process. The whole hide the ball and they only get it in discovery if they ask for it, and all those sorts of mentalities that go with the litigation mindset don't work, and they actually undermine the mediation process. So first, just understanding that, as I'm sure you say all the time on this podcast, very different process, and we have to approach it that way.
Absolutely.
The next thing about it is context. We have to think about where we are and who's involved. You heard Jeff Kitchaven do a really important piece on confidentiality laws. Now that we're doing so much by Zoom and people are in different states and all that sort of thing, we have to be mindful of what the rules are that govern it. A lot of states treat confidentiality like a privilege. In California, it's not a privilege. It's not held or owned by anybody and can't be waived by anybody. It's statutory inadmissibility. So first we have to know the venue, the ground, and what rules we're playing by. My home turf is California.
Yeah.
So I use the California rules most often, and I have people sign off on them in advance, with the caveat that people can't contract to hold evidence out of a court. But in California, we're acknowledging and we're reinforcing the inadmissibility of what you just said, the things they bring to the mediation that they can't become confidential by showing them a mediation if they're otherwise discoverable. Having said that, the protection under California's rules, and I know several states have copied California's rules, is that it's flat out inadmissible that if the judge asks or if anyone offers anything that came out of that mediation, in California, it's grounds for a mistrial. And so the protections are so strong. We've had now 6 cases go to our state Supreme Court over mediation confidentiality, even in some very, very good situations where the argument was strong to poke through the confidentiality bubble of the mediation discussions. The courts held in the public interest to keep mediation confidential and inadmissible, sort of saying the needs of the many outweigh the needs of the few as they were setting public policy. So understanding the ground rules and making sure the parties understand them up front are the most important. And again, the other prong in California, in our evidence code, it literally calls you and me incompetent to testify.
Right.
Saying that we can't bring forward anything that we heard during the mediation, other than accepting somebody punches somebody and creates a crime in the middle of the mediation.
In the middle of the day, yeah.
Right. One of the things I do to answer your question directly, to help people feel that extra level of comfort, especially if it's a tough case or if there are trade secrets or anything else involved, where it feels like a case where confidentiality is extra important. One of the things I do is I let them know that I'm a big believer in that, and that I understand that but for me promising them I won't repeat what they tell me, they wouldn't necessarily tell me all the things they do. And you and I both know they tell us everything eventually, right? I mean,
Yep.
the secrets and everything. I tell them if I were ordered to testify about what they told me in this mediation, I would show up with a toothbrush and sit for contempt, because I promised them, I gave them my words, separate and apart from the statute, that I'm not going to repeat what they tell me. And I take that very, very seriously. So I emphasize that. I start right after good morning, I start talking about confidentiality with folks. And we've already talked about it in a pre-mediation conference call, which we'll talk about later.
Yeah.
I do everything to make them understand that it's safe. And the last little piece to that is you and I both know that when we show up in the room, we have to carry with us that air of safety.
Yeah.
They have to trust us when they look at us and believe us when we tell them that we're going to hold what they tell us confidential.
Yeah, and I think that's a phenomenal way of starting off, and I might steal some of that, the toothbrush piece, because I do think that that's critical, and my wife might tell you that I'm always incompetent to testify, but I think that the statutory privileges that exist, or the statutory protections that exist, are so critical, and I think it's one of the beautiful things about California, and I have litigated in other states. New York is one of the big ones, which doesn't have quite as strong of a statutory protection, but I still try to create as much of that in an environment, and I do want to hear a little bit of your thoughts toward the end about whether there may be ways to contract for that in your mediation agreement, because I do think it's such a critical piece to the mediation process, and I want to get a little bit into the kind of meat and potatoes of that. Maybe you have an anecdote or two to share about a case where the exchange of that information made all the difference, and maybe it's really all of our cases where that exchange makes all the difference. But I think that you have to start from that point of confidentiality and that trust that there is, that it will be protected. I think one of the anecdotes you had given in the past was about a report that was done and maybe tainted water or something for the purpose of mediation, and it was excluded, something to that effect. But I think the ability to define in California, for example, we are going to do the following thing solely for the purpose of mediation so that everyone knows there's privilege. I once produced a client for an independent investigation to be interviewed without any objections from me, solely for the purpose of mediation, solely within the privilege, because I felt confident. We stipulated beforehand, you can't use this as a prior inconsistent statement in the future. You can't use this as evidence. I think it made all the difference. So I would love to get into kind of that piece with you, hear about some of your experiences where that exchange made all the difference.
Fantastic. So one of the things I start with in the morning is that we mediators have fought hard to keep this process confidential. And if you think about it, with all due respect, our enemy in that drive is the court. It's the judges.
Yeah.
And feel entitled to every bit of information they can get their hands on to make better decisions. We're the only ones that have an interest in protecting this process as confidential. So we have opposing perspectives to the court in that scenario.
Yeah.
The case I think you're talking about is the Rojas case, where they did exactly as you just described, and they hired an expert, a mutual expert that all the parties, plaintiff and defendants, all hired jointly to do an inspection about some mold on a property. And then they held those mold findings and the eradication and mitigation of that mold that happened under the umbrella of the mediation, all confidential, including from all the tenants who lived in the building who were having mold issues. So this is what I'm talking about interests that are important. In this case, one of the attorneys for one of the insurance companies pushed back from the table and said, I'm not agreeing to this. It doesn't feel right to me, and left. And then put up notices on the plaintiffs, on the tenants, and said, I'll represent you because your landlord is trying to keep from you. And first thing he did was make a discovery motion and to compel that
report.
And it went through the courts all the way to the Supreme Court, who eventually said, no, we have to protect the confidentiality of this mediation process. And thank goodness that case settled and the tenants got paid before the Supreme Court made that decision while it was pending.
So it kind of helped all around. The victims were, they were successful in something, but it kind of codified that rule, made it pretty clear.
Exactly. And I'll tell you my favorite story, and I haven't talked about this one an awful lot. It's a little complicated. The attorney audience will absolutely understand it. It was a trade secrets case. It was a guy who worked for a manufacturing company, and he was responsible for sales and managing the inbound phone calls from their clients. What he did was, with his cousin, he set up a side business, started importing the same items in their little side business, and he was funneling customers that he would take their inbound calls off to his cousin, saying, this guy can sell you that quantity cheaper than we can, and was making money with his cousin in the side business. They got caught. One of the customers said, wait, what is this? And asked the big company about it. Big company, of course, fired him and sued them. And the motion to compel the disclosure of small companies' bank records in favor of the big company was pending when they came to mediation. So with us all working together, the attorneys and I brainstorming together, we came up with a process where small companies said, we're willing to represent that these 10 customers are the ones that we did business with, who are your customers. We're going to give you the amount of money we did, the amount of business that we did with each one of these customers, and we should negotiate our settlement based on that. Big company said, that's all well and good. We just don't believe you, or you record that tells us we shouldn't, right?
Sure.
So we need this verified. So we started brainstorming. We came up with an idea that using the mediation protection, they produced the bank records to me as the mediator to review in camera. And we came up with a formula where they picked two of the big company picked 2 of the 10 and said, you go through, Lee Jay, the mediator, go through the bank records, tell us how much money they deposited from, how much business they did with those 2 companies. And if it's within a 10% margin of error of what they've represented to us, we'll buy the rest of their numbers and we'll negotiate a settlement based on that. If it's outside of a 10% margin of error, we're gonna have to assume that they're lying to us, and we're gonna have to dig deeper to find out.
Yeah.
Only using that mediation protection were they able to verify the records. It turned out that they had been within 10%, in fact, within 5%, I think, of the actual deposits, because I saw every deposit that went in.
Sure.
And was able to verify that for them, so we could move forward with a settlement based on the numbers they had represented.
Wow.
Yeah, and in a trade secrets case where it's you get the information or you don't get the information, and the court decides, small company would have been put out of business if all of their customer information had gone to big company.
Mm-hmm.
Big company would have dropped their prices and put them out of business in 2 seconds.
They would have had that information. Yeah.
So a situation like that, that's a creative use of the mediation confidentiality, is a great example of that. There's another partnership dissolution case where one partner was embezzling, his wife actually was embezzling from the company. And we were able to talk about that and bring the records into mediation solely for the purposes of mediation. They prepared a summary and all of that the same way. And we were able to resolve that case because of the inadmissibility of the mediation process.
Yeah, I think those are 2 great examples, and I'm actually really curious because both of those involved you as kind of a special master, if you will, or someone sitting in between. And I always try, at least the way I do it, is I try to encourage exchanging them directly with each other solely within the mediation process. But at the least, can you share it with me to share it with the other side? And being a mediator, you need to have that credibility to be able to say, both sides trust that I've reviewed this and I'm being candid about it. But I am curious if you think you've seen it, work better with the exchange directly. I do really love the fact that with virtual mediations, you have an ability to do this. If I screen share this during the mediation in an executive session, let's say, I can see if someone takes a screenshot, it will pop up, I know. And so it gives that comfort of they're not actually emailing the documents to each other. No one has a physical copy. Back when we were doing it in person, you'd come by, you'd be the custodian, you'd physically carry it to the other side, you let them read it, you take it back, you go, So do you like that exchange if you can get it between each other directly, or do you prefer to be the middle person?
No, absolutely. Direct is best. These were situations where that obviously wouldn't have worked.
Yeah.
Direct exchange is the best. And I've gone so far as to send links to our evidence code to both counsel so they could read it and advise their clients to give their clients a comfort level in preparing documents solely for the purpose of mediation, which is, the terms of art here in California.
Yeah.
And encouraging them to share them. And it makes all the difference in the world, because what helps a case settle, Dan Rather said it years ago. He said, where are the common facts upon which we can disagree? Because right now,
there you go.
Fact. And in litigation, everybody's buying their own press releases. Everybody believes their side of the story, and the lawyers pretend at least to believe everything the client tells them. And you've got disparate views on a case where one side thinks it's worth 40 million and the other side thinks it's worth 400,000. And
yeah,
the only thing that's going to close that gap, compromise, is not going to close that gap. Right? That case is not going to go back and forth and settle at $12.5 million from that kind of a starting place. The only thing that brings people closer together is having a better understanding of the facts, so they see the case more similarly to each other. They'll apply their theories, they'll apply their the law the way they see it. But the more we can have a common set of facts to work from, the more sane this process is. And
yeah,
I'm sure you're telling your people all the time in mediation, the thing that makes the difference is that the cost of the litigation process is almost always around attaining that similar set of facts. Let's get to the bottom of what these damages actually were, and then we can have a negotiation about how much of that is owed.
Right.
But oftentimes that doesn't happen until you're halfway through a trial.
Yeah.
Suddenly people are saying, oh gosh, I wish we'd known this sooner. We could have saved all of these months and years and dollars and everything else. So I think that's part of what we offer them, is the ability and the coverage and the protection to bring those common facts out sooner and ask each other's experts questions and things. I have a mediation coming up Tuesday. It's a construction defect case, and the roofing experts just can't agree. They got together on their own. Mm-hmm. So we're going to have a facilitated session with just the roofing experts and the attorneys, with the insurance adjusters all listening in. And we're going to try and figure out what's actually happening with the roof, because it's a fact, right? Something
right
there, they don't get separate, they can have separate interpretations of it.
Sure.
Apart from separate places.
There still are things that are actual fact even today. And no, I think that's a great point. And I'm curious about when you start to try to facilitate that exchange, how early on in the process, because I do think that if you can exchange it early enough, having the right people see it is more critical. And I really loved when I was litigating, when a mediator would pull me into an executive session with the other attorneys and say, go ahead and give a small opening statement at the beginning of a trial. Let them see how you've cohesively laid out these facts and this evidence the way a jury will see it, and then let's flip it to the other side so you both get that kind of experience as early on as possible. But oftentimes, especially if there's insurance involved, getting it the day of the mediation is tough. And so pre-mediation calls, asking for that as early as possible, I think becomes critical. When do you start to ask for it, and how do you go about helping the lawyers do a better job of gathering the things, the documents, the information that you think will be helpful in the mediation?
So you hit the nail on the head when you said pre-mediation phone calls, but to me, that's a subset of how I see the mediation process morphing and evolving. And I think good, strong mediators like you, Abe, call people together and almost take on the role of a case management conference and act as a case manager for them. And I don't mean case manager scheduling the mediation, but I mean literally saying, what are the issues you agree on? What are the issues you don't agree on? What documents do you need to help where you don't agree? And acting like a judge would in a case management conference. If you need more discovery to prepare for mediation, not for trial, what do you need before you can come to the table and be prepared to make a solid settlement recommendation to your client? And let's get those things done before the mediation. So I call it exchange of information rather than discovery, because it's voluntary exchange. It's oftentimes within the mediation protection, so that they understand that what they prepare as a summary or in some other fashion, or like your unbounded deposition.
Yeah.
Those things can be protected and can be completed well in advance of the mediation. So when I get a phone call that says, hey, we've picked you to mediate this case or whatever, my case manager knows immediately to say, great, let's get on a conference call on Zoom in the next week or 10 days. And on that call, we'll do the logistics. We'll do who needs to be in the room, how much time do we need to prepare, when's a good target time, we should be looking at dates. And we'll pull calendars out, we'll do it all right there on the Zoom. And we'll also do some of that case management conference kind of stuff where we'll ask what they need in order to be prepared. We'll make sure that we get it, as you've said, in the insurance adjuster's hands, ideally 30 days or more before the mediation, so they can run it up the flagpole and get their authority and have their discussions about their exposure and know all of those things before walking in the door to the mediation.
That's interesting because I think, the joint calls that we used to have a lot of where all counsel get on one call with the mediator a month or two before, where you do get that, you're the magistrate judge playing that role. I think a lot of people have done away with that. Do you find that to be helpful? I know that my practice is I want my briefs at least a week before so that I can read them and look through them and find the things that I think you need. Even if you don't realize it, these are things I think you need to get this done, give you at least a few days. But I think that would be even better if you get 30 days beforehand. So do you like having those calls?
I still do. And I think that you're right. Best practice would be all the above, right? Let's have an opening call with all counsel, then read the briefs and call them back up with more questions and more probing and more suggestions of what to be prepared for when they come and all of those sorts of things. I, like a lot of us, don't have the time for all of that.
Yeah.
Do the initial call with all counsel together. And it's always a trade-off, right? If you have each counsel separately, they're going to tell you about their own client. They're going to tell you about the other lawyer, and they're going to give you more insights to those things. By having them together, I get to see the relationship between them. Are they cordial and collegial and professional, or are they snarky and sniping and bitter with each other? And is it going to be a knockdown, drag out kind of a mediation? And I'll ask them about positive things, what they agree on, what I need to know about their clients, and so on. And I'm doing everything I can to start the communication early. And then the more communication that follows that in advance of the mediation, the better the chances the mediation is going to make everybody happy on the day.
Sure. So do you like to flag those issues for them, or do you feel like it's more their process, let them talk to each other? Because I'll do a lot of, listen, I litigated these cases for a long time. If you don't have these mitigation documents, the adjuster's going to be asking for that. Or on the other side, look, here's a victim impact video, which is something I've started to see people do even in employment cases. The adjuster is not seeing the plaintiff. They didn't work with the plaintiff. They want to be able to assess how they'll be at a trial, or so I think it's interesting because I agree, the earlier you can get that conversation going, the better. But then at the same time, once I've had a chance to really review the briefs and the exhibits, I have a better ability as the mediator to go to them and say, you guys are missing chunks here that you need to be exchanging. So what do you think is a good middle ground, recognizing that we only have so much time as mediators to do this prep?
True. So let's start with the premise that, as I see it, there's sort of three ways to influence somebody else. You can come from a place of authority above them, where you can say, and you sound like you do this to a degree, I know what needs to happen here. Let me tell you what I think you're missing. And you come from a place of more authority. Retired judges deal from that place all the time. Then there's the peer-to-peer that sort of says, you and I both know this is what's going to happen. This piece of evidence is going to be difficult to get in. This witness, you can't count on necessarily because they appear on their list also, and things like that. But it's very peer-to-peer. We've all done this before. We all know what tends to happen. The third piece is sort of from below. It's a place that has to come from humility. I never tried cases. I mean, my background is not the law. My background is business. Mm-hmm. For me, I can't do what you do and pick the, I could.
You can. Now, at this stage in your career, I think you know more about the law than many lawyers I know. But maybe early on you couldn't. Fair enough.
Yeah, and I wouldn't presume to, right?
Yeah.
The lawyers who are trying the case, they don't want some mediator coming in who hasn't stood before a jury and hasn't filed the motions and those sorts of things to tell them what they should do. So I have to come from a different angle than you do. And I come from a place that says, if I were on your jury, I would think it would be important to see this part of the case. And I want to better understand the chronology and how this played out in timing wise. And I'd like to see that kind of an impact video So for me, I come from a place it's got the same goal in mind, but the approach, the style is just different than yours.
Yeah.
It's from authority and from having done it before, just like they do it.
Yeah, and I try to do it in kind of a neutral way where it's not I know this is going to, it's more of, like you said, the peer-to-peer, we know these are critical things people want to know. But yeah, I agree. Whatever angle you're coming from, I think, it's not even I'm an expert, you must listen to me about whether to settle this for XYZ. It's we both know that the other side is going to be, frankly, they've asked me for this in my call with them or whatever it might be. So let's get a little bit into maybe what I find to be the more interesting piece of this, the fun piece. And that is what happens when you have issues with that confidentiality in California as well. But, I had cases as a litigator where I gave over information in a mediation that suddenly that witness, when they were deposed, remembered things differently because clearly they had seen what I gave over. Or where I had a mediation not long ago in California where it was a small business that was being sued by an employee, and the attorney for the employee was a very smart attorney, and the business was saying, we're a small business, we don't have any money. So I facilitated a session between the lawyers where the defense lawyer literally put up on a screen share the books of the business, and the plaintiff's lawyer looked and took close notes, and he discovered very keenly that about $1 million had been funneled out of the business into a brand new bank account. And it became this whole conversation, they're hiding money, and it ended up settling the case in many ways on the defense side, and on the plaintiff side, it drove up the value to some degree. But one of the pieces that became, I think, a dicey issue that I had to consult with some of my gurus, some of the people that you know well as mediators, was when the plaintiff's lawyer said to me, well, if this doesn't settle today, we're going to, go after all these books in this discovery. And now we know, well, it's a fine line. Maybe that is a question they would have asked in discovery. At this point, they'd already exchanged discovery demands, and that wasn't one of them. And, what do you do as the mediator when you start to see that develop where the sanctity of that confidentiality becomes an issue, and the fact that can affect the credibility of this exchange of information? How do you maybe account for that from, on the front end? We talked a little bit about that, and, kind of on the back end when it comes up.
So I think you said it earlier, I think timing is everything. And I think asking people at the get-go to disclose the books and records of the business, they're going to be afraid, they're going to be careful, and they're going to give you and I pushback for the very reason that you're citing. So what I found is if we can get them close enough that they have confidence that the other side is here for real and really wants to settle, now it's just a question of how much. Now let them see that sort of smoking gun evidence, if that's the situation. I had a case one time where they were sitting on some records and they said, we want to show you this, but we don't want to show them this yet because we want to save it for surprise at his deposition. Mm-hmm. I mean, the same thing we always hear. And what they showed me were 6 certified copies of bankruptcy filings by the same person with slightly different names and the same social and everything else in the last 18 months.
Wow.
And so he was saying, I don't have any money and blah, blah, blah. And I said to them, look, he's offering something reasonable. So he's not here trying to cry poor and offer new you and hope that you'll take it. If you don't share this with them, you're guaranteeing yourself a trial, or at least a deposition where you spring this on them. And you're delaying resolution for another 3 to 6 months. And you're going to spend all the time and money between now and then. Whereas if you put it on the table now, I feel confident, and I want you to feel confident at some point, that we can get this done today and get you and your client with me now and not have that further delay. And I wouldn't ask you this at 9 o'clock in the morning, but now that we're sitting here at 1 in the afternoon and we see how the day is unfolding, I, for one, have confidence that you'll get the right result from showing them this now, rather than what value you're trying to preserve to save that position.
I think that's a great way of putting it, yeah.
Yeah, and besides, what you're holding in your hand isn't going to go away. They can't concoct a story between now and then to explain away 6 bankruptcy filings.
Yeah, it's tough to tell, and I'll say as a litigator, I mean, I very distinctly remember one case early on in my career where in the mediation, and they never offered more than, I don't know, $5,000-$10,000. So it was, they were there in bad faith. But in the mediation, I had pointed out that there was a discrepancy between a date that they claimed in their records. They had written up an employee for, certain conduct, and then there's a complaint after. And, the question was when the bad conduct by the employee started. And I had the time records, which was a key card time record that showed the employee was not there that day. They were on vacation. And suddenly at the deposition, after it didn't settle, the person who, wrote the notes to say, well, I had the conversation. Now it became, well, I had a phone conversation. I called the employee off. Yeah. So it's an interesting thing that I think lawyers grapple with. And I think the message I have, and I'd be curious if you have a different message to the lawyers, is more often than not, they're going to get this information. And this is the debate we would always have internally, whether I was on the defense or the plaintiff side, is if I share this information, are they going to get this in discovery anyway? No matter how much I fight, maybe I get a little value of when I surprise them with it. But if they're going to, and it's clear they're actually here in good faith, like you said, they've put some real money on the table already. They're not here in bad faith. Let's show them everything there is.
And this comes back to this being a different process, right? It's not all. It's you put everything on the table and make them pay you for what that's worth if you're the plaintiff. I mean, that's the only way they're going to come to an assessment of value that's anywhere similar to a plaintiff's side, is if they see everything the plaintiff has. And vice versa, if the defendant has, Sabrosa films or, gun, they've got to be able to bring the plaintiff's expectations into line so the case can settle. And settlement is really the goal, and closing the file and disposing of it and being done with it is really the goal. They've got to break some old bad habits.
Yeah.
Litigation.
They have to take away that, positional, we are fighting type of mentality, and, close cases, as Ralph Williams likes to say. That's what we do. As a mediator, we close cases. So I appreciate you taking a lot of time already. So I want to kind of just shift to the closing piece of this, which is, are there any pet peeves that you have surrounding this topic, or really any other, where you really wish more lawyers knew going into the mediation process, this piece of information or this value, to make it easier, help us as the mediators help them to resolve these disputes? Absolutely. And it's a cousin to what you just said. And it comes back to trust. I had a client in a really bad burn case one time say to me in a joint session, I know not to listen to anything you tell me. My lawyer warned me that you're just going to try to get me to settle. Wow. And that you're the enemy today, and to not listen to anything you say. Wow. I felt so bad for the client that the lawyer had done that, because I think the one thing that lawyers miss most, and it comes from a place of trust, I assume, is embracing us onto their side. You and I, we do this every day, right? We've studied it forward and backward. You litigated before. I've done this 28 years. We know the game. We're also, a lot of days, we're the only ones seeing the people in the other room because they're in separate rooms all day long. Yeah. Temperature, we know who's calling the shots. We know secret information that we've not been allowed to share. If we're trying to guide them towards something, it's our job to build that rapport and trust with them. But a good lawyer is going to engage us as a consultant on their negotiation plan and on their case in the mediation. It sounds like yours do that well, and you earn that respect with them. But we are there as a resource for them. They don't ask us often enough, what do you think of the offer that we're about to make? Yeah. Am I doing the right thing? Is there something that I'm missing? Is there something you would do differently? What I love is when they say, let me hear how you're going to present that in the other room. Because they want to know, am I really going to sell it, or am I going to just say, here's a number? Yeah. Exactly. And what that does is it builds trust, because we're all working together in that room on the same page and from the same script. So I love when lawyers, if a lawyer has a client who's unreasonable, but the lawyer's busy advocating and won't let the client really engage with us, for example, I think that's a mistake. It's a disservice, yeah.
Yeah, a good lawyer who knows that the client is being unreasonable will step out of the way and do sort of that matador defense and let us talk to the client about the real world and what it's like out there. And how many people call us months after the mediation and say, my gosh, I wish I had taken that offer you told me I should take that was on the table, because
Yep.
the trial and I got half that and it cost me all this, and all of that sort of thing. So I think there's a well of information that we carry from all the training we do, from all the experience that we have, the numbers of cases that we've helped settle as mediators, that we should be a resource to them rather than them standing back at arm's length and not trusting us and trying to hide the ball from us as well. We can't help them that way. And so they're not getting any added value from us. They're just getting a message carrier that goes from room to room with a number.
Right. You don't get the real value. I think that's spot on. That's exactly maybe the most critical piece, because I do think at the beginning, there's oftentimes this trust factor where the client needs to watch the lawyer advocate for them a little bit. But at a certain point, you gotta step aside and let the mediator be able to engage and talk through what the concerns are. Again, if that's the type of a client who needs it, but more often than not, it is. So I think that's a great point, and I think the lawyers should be prepping the clients. This is someone who has lots of experience. They get it. They understand it. They're neutral. They don't have a horse in this race. It's, listen to them. Let's hear what they have to say. And I will say that the one piece you said about the, trusting, the lawyers trusting us as the mediators, the biggest way that the mediators I mediated with when I litigated would build a rapport with me, a trust with me, is if I had said to them, I'm thinking of dropping this much from my starting number. What do you think of that? And sometimes they said, that's too big of a drop. We're too early for that. Don't make that big of a drop yet. The other side needs to move the pieces more slowly, versus actually that's not enough of a drop. I need a bigger drop than that. And as you engage with that same mediator multiple times and build that rapport, I think absolutely the lawyer should start to trust the process a little bit. So
Yeah. I had one med mal defense attorney. We did a number of wrongful death cases and things together, and he would always give me two numbers and say, which one do you think? And on the defense side, the first couple of times I would always tell him the higher number, because I'd explained to him that we need to build momentum. They need to see that you're here for real. And each time you're moving, 10,000, they're moving 30,000. And so you're getting bang for your buck in the negotiation. But I knew if I constantly went with the highest number, I'd lose his trust.
mm-hmm.
So there were times I would say, let's pump the brakes a little bit right now. That extra little bit isn't going to get you more back from the other side. Let's go with the lower of those two numbers and let's see what we get back this time. But it was always, notice the language. Psychologists say you never put yourself in the lifeboat with your clients, your patients. but for me, it's always we, us, let's.
Yes.
Together, and I'm coaching in both rooms. Then I go in the other room and say, well, they did this. Now, how do we want to respond to that? And I've just got a different colored jersey on, and I'm helping them also, because there's an old Zig Ziglar line. The Zig Ziglar
Sure.
trainer, right? You really can get what you want out of life if you just help enough other people get what they want. And that's
I like that.
mediation. That's kind of my mantra. Like, if I can help everybody get as much of what they want as they came for, whether it's monetary or non-economic or whatever it is, then everybody's going to be happier and I'm going to have more business.
Yeah, I love that. I think I'm going to paint the word we right on the wall in front of me, because I think that's the most critical one. It's not I, it's we. How are we going to push this across the finish line? So, which is a good segue to say thank you so much. I'll give you one last opportunity to just say, is there anything you really love about mediation that you want to share with people? What do you love most about it? And then we'll kind of conclude there.
I love the shift the most. I love when the clients especially walk into the room at 9 o'clock if we're in person, and if there's a joint session, not necessarily first thing in the morning, but when they're first in the same room, they don't even want to look at each other. They've said horrible things about each other and all of that. And by 6 o'clock, the lawyers and I are sitting and crafting the settlement agreement, and they're sitting in back showing each other pictures of the kids and how much they've grown. And, I love that shift. It doesn't always happen, but if not the shift in their relationship, then at least the relief I can see from them in separate rooms, that they're just so relieved that it's over and they can see tomorrow being different than yesterday was. And I love being a part of helping to make that happen.
I love it. I think that's great. And I appreciate you offering that insight, really to the lawyers out there who are engaging in these mediations, to help them better help us help them. I know that's a convoluted line, but that's really what it comes down to. So
It's very accurate.
we really appreciate you taking the time, and hopefully look forward to welcoming you back at some point in the future on another topic. But thank you so much, Lee Jay. Truly appreciate it.
My pleasure. Thanks for having me, Abe. Great show.
Without an audience, we would be nothing. So I'd like to thank you, the listener, for tuning in to another episode of Mediator in the Middle. Please take the time to subscribe on your favorite podcast platform, Spotify, Apple, whatever it might be. And please feel free to refer a friend. Until next time, we look forward to seeing you, and keep calm and mediate on. Thank you.